The kid's not mine. When I was in a relationship with her, I thought the kid was mine.
The whole truth and nothing but the truth.
Yes, Your Honor.
You may lower your hand, sir. And Ms. Peoples, you may proceed.
Thank you, Judge. Judge, this case parties were present. There was a non-agreed child support review order to modify the child support. Judge, the mother, Natasha Jeffrey, was present. She agreed to the modification. However, Mr. Daniels, who's present today, did not agree to the modification terms. If I could take testimony from him.
You may.
Mr. Daniels, can you state your full name?
Jermaine Renard Daniels.
And Mr. Daniels, you understand that the child support review order that was done modified your child support based on the income information that we had on file for you?
Yes.
Right. And you have one child before the court in this case, is that right?
Yes.
And you understand we did take into consideration or give you credit for your 3 other children. You understand that?
Yes.
And you understand that the mother, Ms. Jeffrey, has medical insurance as well as dental insurance through her employer. And the proposed order requests a cash medical support of $91 a month beginning May 1st, 2025. You understand that?
Yes.
And that it also requests a cash dental support of $15 a month beginning May 1st, 2025. You understand that?
Yes.
And that
One second, Ms. Peoples. What was the medical?
it was $91 a month, Judge.
Okay. Thank you.
And Mr. Daniels, you understand that child support at 14.75% of your net resources would be $490 a month, also beginning May 1st, 2025.
Yes.
And you disagree with all of those numbers, is that correct?
Yes.
Right. You're asking, or you do not want to be ordered to pay any child support going forward?
I shouldn't pay an increase. I know that that's not going to happen since I've never agreed on paternity. I feel it should at least remain the same until I can get paternity established. I've been denied paternity in the beginning of this case. I've never agreed to any paternity. So
you don't want an increase, you want the child support to stay what it's currently set at?
yes, I believe that's the only other option.
And you understand that currently right now, the child support obligation, right now you're ordered to pay $265 a month in child support and $60 in medical.
Yes.
And that's what you're wanting the court to keep the same as far as the child support.
Yes.
But you understand that the order does now increase your child support because your income has changed since the 2015 order.
Even though all my cases have increased within the past week, they've all increased at the same time. So I won't be allowed an opportunity to find more work, more income or anything.
Okay. I'll pass the witness, Judge.
Okay. Mr. Daniels?
Yes, ma'am.
Do you have anything else you wanted to tell me, sir?
I've never been given the opportunity to establish paternity or to fight paternity on this case. I've never believed the child is mine. I still don't. So I'm not going to agree to any increase.
Okay. And I understand that, Mr. Daniels, but in 2015, there was
2015, I was denied paternity before, and they still ordered me to pay child support.
Okay. In 2015, did you sign an acknowledgement of paternity?
I've never agreed to paternity. I've never believed the child was mine. So
Miss Peoples, can you give me some background?
Yes, Judge. So the 2015 order was a default order establishing paternity.
Okay.
Mr. Daniels wasn't present when that original order was done, and then this is the first time that it is being modified for the child support.
Okay, so Mr. Daniels, you wasn't denied paternity. You didn't participate in the suit in 2015.
But I asked for paternity.
There's a difference.
Okay. I've asked for paternity. I've been asked for paternity. Everyone keeps giving me excuses why.
Mr. Daniels, there's a proper way to challenge that order, and you haven't done that. So just asking for paternity is not the way you challenge that order. You might want to consult with a private attorney or go to the law library and do the research yourself, but that's not a proper way to attack that order. Okay. That order has been in place for 10 years now.
And I asked for paternity before the order was established. I was told no and still ordered to pay child support.
Mr. Daniels, it doesn't matter. Now that that order has been put in place, there's a way to attack that order. And you have not taken the proper steps to attack that order. Okay. I wasn't there in 2015, so I don't know what happened in 2015. I know that I have what appears to be a valid order, and so I have to enforce that order. And we're not enforcing the order at this point, we're modifying the order. And you haven't given me a valid legal reason not to modify it.
Because we weren't even together. At the point when she got pregnant, we had just broken up, and no one's even asked that question this entire time.
Because you didn't participate in you got defaulted. You weren't at the hearing, sir.
Okay,
At this point, all of that is mute until none of that matters until you properly attack the underlying order. So until you consult with a private attorney or go to the law library and do the research yourself, you can tell me a myriad of things, but none of them legally change the fact that you're obligated to support this child and that they can come in and ask that that obligation be modified. Do you understand? You're telling me, you're giving me evidence, but the evidence doesn't matter until you properly attack the order. There are ways to get an order overturned, but you have to do it properly. You can't just come in and make these statements, okay?
Okay, will I be given any assistance in that and to get the ball rolling on that front today or no?
Not from the court, sir, and the AG's office. That's not what they're in the business of doing. They're not in the business of attacking their own orders unless they made a mistake. So now that I've explained all of that to you, what I am going to confirm this non-agreed CSRP as is. So the terms of the CSRP will go into effect. What's the start date, Ms. Peoples?
May 1st, Judge.
Okay, they'll go into effect on May 1st.
So she's still getting an increase?
Yes, sir.
Okay. I missed one court date and the book is thrown at me. She's not here today and she still gets awarded the increase. I'm not understanding that.
Because she's already signed the order. She already did her part when she appeared at the negotiation conference. I don't need her here today because she's already told me she agrees to this order.
Okay, and you're aware that all my other cases have increased within the past week. They've all gone up at the same time.
I'm sure that all of those orders gave you credit for your other children.
Okay.
As long as they give you credit for the other children, they can all go up. They can all be modified. Anything further, sir? If you have no further questions, then thank you for appearing here today and you're free to go.
Thank you, Judge. We're on the state's suit affecting the parent-child relationship. Judge, if I can call the courtroom to confirm the mother isn't present.
You may.
Is Nina Aguilar present in the courtroom? Nina Aguilar? Is Nina Aguilar present in the courtroom? Judge, Ms. Aguilar is not present and hasn't filed an answer. She has been served, so the state is requesting to proceed with the default.
You may.
Well, I guess, Judge, the first issue is the child in this case, Natalie Guevara. There is an acknowledgement of paternity that was signed. I'd offer it as State's Exhibit A, which is the pleading. It was attached to the pleading on file.
State's Exhibit A is admitted.
Thank you, Judge. Mr. Guevara is present. He is requesting DNA for this child. However, the state is opposed because of the acknowledgement of paternity that was signed. If I could take testimony from him on that issue.
You may.
Sir, can you state your full name?
Martin Guevara.
And Mr. Guevara, you are currently asking the court for DNA for the child Natalie Guevara?
Yes.
And you understand that you signed an acknowledgement of paternity at birth when Natalie was born?
Correct, when we were in a relationship.
Okay, but you're asking the court for DNA?
Correct. I did my outside DNA already, outside DNA test, but I'm requesting it through y'all now.
Okay, and what reason, as far as what did you, is there anything else you want the court to know as far as your request for DNA?
The kid's not mine.
And you made aware of that through an outside DNA test?
Correct, correct. That's why I'm trying to go through this process of showing up and showing my face and requesting a DNA test. Correct. When I was in a relationship with her, I thought the kid was mine, but did a DNA test a couple months later after the baby was born. Not my kid, so I'm trying to just go through the process of requesting a DNA test, doing all this.
How old is the child?
I don't know now. I mean, it's been, I think she's probably like 3 years old now. I haven't been with her for 3 years now.
Okay.
So, Judge, the child was born in 2021, July of 2021.
Okay. Then I will grant the DNA testing.
Okay, Judge. And the state will be requesting a reset to July 16th.
Okay, sir, this case will be reset to July 16, 2025 at 8:30 a.m. You will need to be present on that date and at that time. If you are not, a default order can be entered against you. Do you understand, sir?
Yes, ma'am.
You also need to participate in the DNA testing on the date that the agency schedules you or as close to that date as possible so that when we return to this courtroom on July 16th, the results will be available. You understand that also, sir?
Yes.
All right, then thank you for appearing here today and you're free to go.
Can I ask you one question, please?
Oh, yes, sir.
So, what would be the next step if, because I haven't been in contact with this girl in years now. Well, I've tried getting in contact, but I get ignored. What happens if she doesn't? I've been to every meeting y'all called me upon. She doesn't show up. I'm requesting a DNA test. What if she doesn't show up to that? What do I need to do? You know, do I need to just keep being patient and just keep going through this process?
I really can't tell you what to do. The next move would be based on what the Attorney General asks for after that. What I would tell you is keep showing up. Don't ever not
Okay.
show up.
I'm
Okay?
here.
All
I'm here.
Okay, then thank you for appearing here today and you're free to go.
Thank you.
Anything else, Miss Peoples?
Judge, I have one more. It's no parties, so I think Ms. Wilson is going to approach first. She has a case with parties.
Okay.
Are you both swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
All right. Make sure you're unmuted, Mr. Miranda, and make sure you're parked. All right, Ms. Hutchins, you want to proceed? Is this the non-pro-tunc?
Yes, Your Honor, the state's approaching with a motion for non-protunct. In our order, we had a clerical mistake listing the date for child support on January 1st, 2024, and the state's asking to correct that error to read January 1st, 2025.
Okay.
The parties were served, Your Honor, by e-service.
Okay, we're not here to restart the whole thing or rehear the case. I know y'all might not agreed back at the last hearing. I don't remember why, but I just note that you didn't agree on everything. We're not here to start over again. They're just trying to make the correction to the proposed order to have the right start date. That's all we're trying to do here today, is just to make that correction. So, Ms. Romero, are you in agreement with that correction?
Yes.
All right. Mr. Miranda, are you in agreement with that correction?
Yes.
Okay. All right, then they will submit me a new order with that corrected, and that'll be it. Y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
Thank you.